The Equal Pay Act prohibits employers from discriminating by paying lower wages to employees of one sex than to employees of the opposite sex by performing, and the key word in here is the similar job requiring similar skills, efforts, and responsibilities, and performed under, again, similar working conditions in the similar working establishment. Now, similar job and similar working environment is something that needs to be qualified somewhat. When it comes to the job, the Equal Pay Act does not require for it to be identical. It's enough to be substantially equal. And the equality of the job is not is not defined by job title, but the job content, which can further be deduced from job descriptions, job specifications, and such. Now, the second controlling factor, along with a job being substantially equal, is the comparable worth of the job. And as I said, the job does not have to be equal. The job has to be comparable in terms of its worth, and of course that is defined by prevailing market sources. Now, the second factor, the working environment, the working conditions, is usually less controversial and has to do with hazards and physical surroundings, which again have to be similar in nature. Now, a few additional remarks when it comes to the Equal Pay Act. We have to remember that the Act allows for some flexibility, and companies can create some defenses for disparities in pay between males and females. And those exceptions can be based on the following: the seniority system, the merit system that measures performance by quantity and quality, the differential based on any other factor other than that. So as we can see, there's quite a broad range of defenses company can deploy. However, in all of those cases, when it comes to those exceptions, very strong BFOQ, remember, bona fide occupational qualification, it must be established, and most importantly, communicated clearly with the workforce beforehand, not post facto. Additional remarks on the Equal Pay Act. There is a 2-year statute of limitation bringing up lawsuit. A charge may be filed with both the EEOC or go straight to court. Employer carries the burden of proof of a good reason for the wage disparity. We talked about it a second ago. Strong BFOQ has to be established. Equal wages must be paid in the same form, meaning the employer cannot try to equalize lower wages of females through a bonus, for example. And finally, if inequality exists, employers cannot lower wages of either sex to equalize pay. And finally, some recent developments on the Equal Pay Act. Starting in March 2018, employers with 100 and more employees are required to report on the W-2 earnings and hours worked by race, ethnicity, and gender. Of course, that brings criticism on Big Brother collecting and accumulating data and employee privacy, but that's a separate issue. And finally, on a state level, state of Maryland introduced legislation regarding prohibiting discrimination based on gender identity. Did something new, which is, of course, to create litigation uncertainty. Um, and but that's something that we all should be aware of.